The video will be played in 3, 2, 1.
Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Good morning, selamat pagi. We wish to welcome the Honorable President of International Law Association, Indonesian branch, and the Head of International Law Department, Faculty of Law, Universitas Padjadjaran, Professor Atif Latiful Hayat, the Honorable Keynote Speaker, Professor Tomiko, former President of the Conference on the Law of the Sea and the Chairman of the Center for International Law at National University of Singapore. The honorable discussants, namely Mr. Lowell Bautista, PhD, Senior Lecturer and Head of Postgraduate Studies, School of Law, University of Wollongong, Australia, and Mr. Gusman Siswandi, PhD, Assistant Professor and the Vice Dean of Faculty of Law, Universitas Padjadjaran. The Honorable Moderator, Mrs. Chlorine Tri Isana Dewi, LLM, Lecturer of Faculty of Law, Universitas Padjadjaran, and the honorable participants. A very good morning to all of you. Welcome to the International Association Indonesian Branch Dialogue, Mochtar and the Law of the Sea, How Indonesia Became an Archipelagic State. My name is Renata, and I will be your master of ceremony for this event. It is a privilege and a great honor to have the presence of this international lecture, and on behalf of the host, we would like to extend our greatest appreciation to each and every one of you for being able to attend this event. Ladies and gentlemen, please allow me first and foremost to inform you of this morning program. Today, there will be a prologue delivered by the President of International Association Indonesian branch and followed by a general lecture delivered by Professor Tomiko. And after that, there will be 2 discussions, which will be discussed by Mr. Lowell Bautista, PhD, and Mr. Gusman Siswandi, PhD, followed by a question and answer session. And before the first session starts, please allow me to explain some of the meeting guidelines. First of all, please mute your audio during the sessions, and you may activate your audio during the Q&A session. Second, we recommend you to activate your video. Third, please follow the instruction to change your username, which is your institution _ your name. And fourth, you may deliver the questions through the chat box. And if you wish to deliver it directly, please use the raise hand function in the participants menu. Ladies and gentlemen, moving on to our next agenda, we will have a prologue delivered by Professor Atif Latiful Hayat. In that case, please allow me to introduce Professor Atif Latiful Hayat. Ladies and gentlemen, Professor Atif Latiful Hayat is a professor of international law and the head of International Law Department, Faculty of Law, Universitas Pajajaran. And he is the president of International Law Association Indonesian branch, and his field of expertise are international law, air and space law, the law of international treaty, human rights law, and the theory of law. He has published books and articles in the area of international law, both in national and international journals. And ladies and gentlemen, let us welcome Professor Atif Latiful Hayat. Professor Atif, the screen is yours.
Thank you, Renata. Assalamualaikum warahmatullahi wabarakatuh. Good morning to all of you. As the presidents of the International Law Associations, the branch of Indonesia, and also the head of International Department, Faculty of Law, Pajajaran University, I welcome you all to International Law Association Dialogue with the special topic today, how Indonesia became an archipelagic state. This event is dedicated to Professor Mochtar Kusumaatmadja, former Prime Minister of the Republic of Indonesia, former Rector of University of Pajajaran, and former head of delegations to the Conference on the Law of the Sea, who has passed away on 6th of June this year. We are honored that this seminar is attended by Honorable Professor Tomiko, former president of the Conference on the Law of the Sea. So today we can obtain the significant information from the first hand from Professor Tomiko. Professor Ko is our main speaker today, who will discuss the genesis of archipelagic state from declaration to conventions, and specifically explains how Indonesia became the archipelagic state. I would also like to thank Dr. Lowell Bautista, head of postgraduate studies, School of Law, University of Wollongong, Australia, as our discussions of this seminar, which will specifically discuss the impact of acceptance, the concept of archipelagic state into the law of the sea, to other archipelagic states such as Philippines. And last but not least, my colleague, Dr. Gusman Chato Siswandi, the director of Indonesian Center for Law of the Sea, which will discuss strengthening the Indonesia's maritime diplomacy as the largest archipelagic state, challenges and opportunities. The nations now we call Indonesia was not born as an archipelagic state. Until the middle of the 1950s, nearly all the waters lying between the islands of Indonesia were as open to the ships of all nations as were the waters in the middle of the great oceans. These waters belonged to no state, nor did any state claim any form of jurisdiction over them. As a consequence, Indonesia was made up of hundreds of pieces of territory separated from one another by high seas. Then suddenly, on 13 December 1957, the cabinet of Prime Minister Juanda Kartawijaya declared that the Indonesian government had absolute sovereignty over all the waters lying within straight baselines, drawn between the outermost islands of Indonesia. This baseline, encompassing as they did all the islands making up the country, formed Indonesia, its land and the seas over which the government now asserted sovereignty into a single unified territory for the first time. Professor Mochtar has succeeded in expanding the Indonesia's territory so that it became the largest archipelagic state and a state with longest coastline in the world. Instead of using ballot, he applies the principles of international law. In his seminal book, Pengantar Hukum Internasional, or Introduction to International Law, which was published in 1976, Mochtar admitted that his understanding of law, especially international law, was mostly influenced by two of his students at Yale Law School, Professor Max McDougall and Professor Northrop. McDougall, who is known as the father of policy-oriented approach to international law, views law, especially international law, as a political product that forms a synergistic relationship that gives positive effects between the two, influencing and strengthening each other. Meanwhile, Northrop, that introduces the concept of living law, argues that relations between countries must be based on an effective international legal systems, that is international law, which is able to provide effective solutions of their international problems. Mochtar's approach to international law was confirmed when he represented the government of Indonesia in Bremen Court in 1959. This case was triggered by the Indonesian government policy of nationalizing the Dutch companies, mostly in the field of plantations. The Dutch government asked Indonesia to pay compensation based on the principle of prompt, effective, and adequate. Indonesia rejected the Dutch argument because the nationalization was carried out with the aim of changing the economic structure from colonial to national economy. Indonesia did not reject for paying compensation, but modified its implementation, which not fully based on the principle of prompt, effective, and adequate, but made some adjustment with the economic policy of Indonesia as a new country. The Bremen court agreed with and accepted the Indonesian arguments. In this regard, Mochtar said as follows: when a state gives consent to be bound by international law, it does not mean that the state cannot protect its national interests through national legislation. International law, according to Mochtar, should provide solutions to many international problems and not make itself as a rigid set of norms. The Indonesian archipelago is a unit of land and waters, and that the sea between the island is an inseparable part of the land of the Indonesian state. The word tanah air in Bahasa Indonesia is strong evidence that this concept has concisely penetrated the minds of the Indonesian people. Based on this concept, the archipelagic state may draw strict archipelagic baseline, joining the outermost spines of the outermost islands. Mochtar said as follows: in our language, as in many languages, we have a word for a native country. The French word is patrie, the German word is die Heimat. In Indonesia, it is land, water, which means land and water. Mochtar's ideas were in the same frequency as the efforts and policies of the government at the time to make the concept of an archipelagic state is becoming international norm. There are two fundamental government political decisions, namely the Juanda Declaration on December 13, 1957 on the Indonesian waters, and the promulgation of Law Number 4, 1960 concerning Indonesian waters, which was substantially reinforcements of the Juanda Declaration. The purpose and substance of the two governments' political decision cannot be separated from Indonesia's participations in the two United Nations Conference on the Law of the Sea in Geneva in 1958 and 1960, where Mochtar was a member of the Indonesian delegation at both conferences. The history finally told us that Mochtar was a figure who later became the main actor of how the concept of archipelagic state was fought for almost 25 years, where Mochtar had to convince other countries of the concept. Mochtar realized that the concept of an archipelagic state was only the interest of small number of countries, including Indonesia, while the big countries, including the United States, strongly opposed the concept. Mochtar also realized that the law of the sea was bound in values of Western Europe, so that the concept of archipelagic state proposed by Indonesia would be considered as an unnecessary historical deviations. In this context, it is interesting to note what Mochtar said as follows: so I submit that in studying international law and law of the sea in particular, if we want a truly international view to evolve, we should not base it only on what evolved in Western Europe. Mochtar is very persistent and detailed in explaining the concept of archipelagic state in various international forums, especially at the United Nations. For example, in the third conference on the law of the sea in Caracas in 1974, Mochtar said, Mr. President, thus, an archipelago must be a group of islands grouped together in real sand. An archipelago, therefore, must be distinguished from a chain of islands. Mochtar realized that there were several problems related to the concept of this archipelagic state, both technical and legal. This concept can also be understood and approached in a multidisciplinary manner. While on the other hand, major maritime countries such as the United States are quite consistent in rejecting this concept. Mochtar is confident and optimistic that this concept will eventually be accepted. Mochtar said diplomatically as follows, I hope you agree with me, but even you do not agree, I hope at least that you understand. Mochtar's efforts were finally successful with the signing of the UN Convention on the Law of the Sea in 1982 in Montego Bay, Jamaica on December 1982, which among other things recognized the concept of archipelagic state that Mochtar had fought for almost 25 years, and Indonesia had ratified the conventions with law number 17, year 1985. Thank you very much.
We would like to express our gratitude to Professor Artipati Pulhayat for the remarkable prologue. Therefore, to keep this wonderful moment, we are going to have a photo session together. Ladies and gentlemen, please activate your video. All right. If you're ready, so we are going to take the photo together. Smile for the picture in 3, 2, 1. One more time. 3, 2, 1. Thank you, ladies and gentlemen. And now we will continue to the next session. And this session is going to be chaired by Mrs. Chlorine Dewi LLM. But before we start, please allow me to introduce Mrs. or Ibu Chlorine Dewi LLM. Ladies and gentlemen, she is a researcher and she started her career as a lecturer since 2005 at the Faculty of Law, Universitas Pajajaran, in the subject of human rights law, international law, humanitarian law, and international criminal law. Ibu Chlorine was a consultant for several government institutions, and as an academician, she has published several articles and also journals in the area of international law. And she is now involved in some researches at the Indonesian Center for the Law of the Sea. And she is also coaching the ICRC Humanitarian Law and ICC Moot Court competition. And now I would like to hand over the session to Ibu Chlorine Dewi LLM. Ibu Chlorine, the screen is yours.
Thank you very much, Renata, for the wonderful introductions. Ladies and gentlemen, good morning. Assalamualaikum warahmatullahi wabarakatuh. Before we start the session with a lecture from Prof Tomiko, let me say a quote from Professor Mochtar Kusumaatmadja. Think not like a craftsman, the cobbler, a plumber, or a carpenter, who worked within the confines of existing international law, but as a master builder or architect with a mission to build a new and better world. Mochtar Kusumaatmadja, 1972. That's a quote of Professor Mochtar that motivate us to talk about this issue. As introduced by Professor Artipati Pulhayat, he insisted to have an archipelagic state concept in the UNCLOS, and finally it was accepted as a part of the articles in the UNCLOS. And here we have Professor Tomiko, who is a live witness of the making of this United Nations Conventions on the Law of the Sea and how the struggle of Professor Mochtar and also others. If I may say, Professor Tomiko is the best friend of Professor Mochtar, who also fight for this issue. Ladies and gentlemen, the post of Professor Mochtar Kusumaatmadja on June 6 brought deep condolence and grief for all of us international law enthusiasts, particularly us, the students. Professor Mochtar is a prominent figure, a lawyer, a scholar, a diplomat, who not only gained recognitions nationally, but internationally. By virtue of his effort to focalizing the archipelagic state principle against the Western power, today many countries in the world have been blessing with the established maritime territory. His achievement to advocate the archipelagic state principle is clear evidence that knowledge could be useful for bringing benefits for humankind and creating peace for humanity. In an attempt to obtain more understanding and scrutinize the thoughts of Mochtar Kusumaatmadja regarding the archipelagic state, the ILA Indonesian branch organized ILA Dialogue, a tribute to Mochtar Kusumaatmadja, sovereignty, and the sea. How Indonesia became an archipelagic state. The dialogue, actually, the topic was inspired by the book written by John G. Butcher and R.E. Elson. The book demonstrates the struggling process of the Indonesian diplomats to elevate Indonesian unilateral policy known as the Juanda Declaration 1957 and seeking to gain international recognition. And after more than 2 decades diplomatic campaigns, the struggle was not in vain, since the archipelagic state principle reached international consensus and was adopted under 1982 on United Nations Conventions on the Law of the Sea. And it is important to note that at the time when Indonesian diplomatic campaign was conducted, apart from getting opposition from Western maritime power, Indonesia was also confronted with many national problems. Since Indonesia delegation strives earnestly to craft and build a new regime on archipelagic states with Mochtar as the central figure, all of these obstacles can be overcome. And today, after the archipelagic state principle is recognized internationally, states are enabled to make up numerous islands and other land features to bring the oceans and seas that connect the land territory under the national jurisdictions for exploitations of natural resources, for example, communications and security. And this dialogue intended to, besides introducing the international law and the law of the sea, we also would like to provide a deep understanding on the archipelagic state principle through the historical and contemporary perspective by scrutinizing the book Sovereignty and the Seas, How Indonesia Became an Archipelagic State. And therefore, we have 3 speakers, but we have main speakers, the keynote speakers, the really key persons who was involved in the making of the UNCLOS and how was the struggle of this concept was finally adopted into the UNCLOS. We have Professor Tomiko. Before Professor Tomiko start his lecture, I would like to give a brief introductions of his curriculum vitae. Professor Tomiko is a Singaporean international lawyer, professor, diplomat, and author. He's the chairman of the Center for International Law, National University of Singapore. And he also an ambassador for, at large at Singapore's Ministry of Foreign Affairs, special advisor of the Institute of Policy Studies and chairman of National Heritage Board. He has a lot of responsibilities. It's very, very productive. Professor Tomiko graduated from Raffles Institutions and Suragan Secondary School and received LLB, first class honor from the University of Malaya in Singapore, or now known as the National University of the Singapore. And he took LLM from the Harvard University and postgraduate diploma in criminology from Cambridge University. But now he's digging in the sea. Yeah. No longer playing in the criminology. And he also got LE degrees from Yale University and Monash University, and also awards received award from Columbia University, Stanford University, Georgetown University, and Fletcher School of Law and Diplomacy, and Curtin University. I think I shall. I
think stop there. No, too
stop
long.
There. So many.
Stop there.
Cukup. We have a lot of list of the achievement of Professor Tomiko. Okay, Professor Tomiko, without prolonging you, I would let the screen to be yours. Thank you.
Thank you. Selamat pagi, everybody. Ibu Corinne, our capable moderator,
Selamat pagi.
Professor Pak Atip Latif, the President of the Indonesian branch of the International Law Association and Professor International Law at Pajajaran University, Dr. Lowell Bautista of the Wollongong University in Australia, Professor and Pak Gusman Katu Siswandi of Pajajaran University. Ladies and gentlemen, I wish to thank you all very much for giving me the pleasure of delivering this lecture in memory of my good friend, Prof Mochtar, who passed away on the 6th of June this year at the age of 92. I wish also to thank Pajajaran University and the Ministry of Foreign Affairs of Indonesia for having conferred on me the inaugural Prof Mochtar Award for International Law in 2017. I have very happy memories of my visit to Bandung, and I was particularly happy that Prof Mochtar was able to come from Bogor to join us at the ceremony. Prof Mochtar was born on the 17th of February, 1929 in what was then Batavia in the Dutch East Indies. Prof Mochtar was a nationalist and he had opposed the Dutch colonial rule of Indonesia. After Indonesia had gained its independence, Prof Mochtar studied law at the University of Indonesia in a joint degree, in a double degree program. So he graduated from the University of Indonesia with a bachelor's degree and a master's degree from Yale Law School. He also obtained a PhD from Pajajaran University. Prof Mochtar and I were very old friends. He was the dean of the law school at Pajajaran when I was the dean of the law school in the University of Singapore. We befriended each other and tried to promote cooperation between our two law schools. Prof Mochtar was the Indonesian Minister for Justice from 1974 to 1978 and was the Foreign Minister for 10 years from 1978 to 1988. He was an outstanding justice minister and brought about many reforms of the Indonesian legal system. He was equally successful as foreign minister. History will give him credit for helping to break the impasse over the Cambodian conflict. He managed to persuade Vietnam to attend what came to be known as the Jakarta Informal Meeting, or JIM. And JIM paved the way for France to convene a peace conference in Paris in 1989 and 1991. Prof Mochtar should have been asked by France to be the co-chairman of the peace conference. Prof Mochtar and I met again at the third conference on the law of the sea. He was the leader of the Indonesian delegation, and I led the Singapore delegation. Prof Mochtar's historic mission at the conference was to persuade the world to accept the new concept of an archipelagic state and to recognize Indonesia as an archipelagic state. See, Indonesia had not been successful in 1958 at the first and second UN conferences on the law of the sea. At the third conference, Prof Mochtar had a three-pronged strategy. First, Indonesia would find common cause with other countries which also aspired to be recognized as an archipelagic state. Second, to try to negotiate an agreement with the then two superpowers, the United States and the Soviet Union. And third, to negotiate with Indonesia's two neighbors, Malaysia and Singapore, and to obtain their support. One of the unique features of the third Conference on the Law of the Sea was the establishment of many interest groups, many interest groups. My colleague, Professor Jayakumar, and I have written a very long chapter on the negotiating process of the conference in volume 1 of the University of Virginia commentary on UNCLOS. In our chapter, we had a comprehensive listing of all the interest groups. One such group was the Archipelagic States Group. This group had 4 member countries: Fiji, Indonesia, Mauritius, and Philippines. Mauritius dropped out of the group in the later stages of the conference. And Bahamas, which was not a member of the group, but cooperated closely with the members of the group. The group tried to agree on a negotiating text which could be submitted to the conference. According to Satyanandan of Fiji, in his book, which was published recently, but unfortunately posthumously, Reflections on the Making of the Modern Law of the Sea, is published by NUS Press. According to Satyanandan, and I quote him at page 85, he said, the archipelagic states could not agree on a negotiating text because of the insistence of Indonesia and the Philippines to limit the passage rights of nuclear-powered submarine and nuclear weapon-carrying vessels to the sea lane. Fiji could not go along with their views. So there was no consensus in the Archipelagic States Group, and as a result, they were not able to submit a common text to the conference. I'm not privy to the Indonesian record on the negotiations with the United States and the Soviet Union. According to Satyanandan's book, Indonesia's talks with the United States did not result in an agreement. They couldn't agree. Now, let me now talk about Indonesia's negotiations with Malaysia and Singapore. Since the third conference made all the decisions by consensus, Indonesia knew that if its proposal were opposed by Malaysia or Singapore, or both, then its proposal would be rejected by the conference. There would be no consensus. So it was critical for Prof Mochtar to get the agreement of Malaysia and Singapore to support the proposal. In order to accommodate Malaysia, Prof Mochtar accepted the text of Article 47, paragraph 6 of the convention. What does this paragraph do? In essence, Indonesia accepted a high seas corridor between East Malaysia and West Malaysia. This was Malaysia's demand in return for supporting Indonesia's proposal. This concession was also embodied later on in a bilateral treaty. Prof Mochtar and I had several rounds of negotiation on Singapore's rights and interests. In 1976, Prof Mochtar and I were successful in formulating a text which we jointly submitted to the rapporteur of the second committee, Satyanandan, who was tasked with drafting the single negotiating text on behalf of the committee. And there's a story behind it. You see, in 1976, 2 years after the conference started, we still didn't have a negotiating text. And we were going round in circles, you know? So in 1976, I proposed to the conference that we request the three chairmen of committees 1, 2, and 3 to draft a single negotiating text for our consideration. The conference accepted my proposal, and the three chairmen, Paul Engel, Committee 1, Galinda Paul, Committee 2, Alexander Yango, Committee 3, were given this mandate. Unfortunately, Ambassador Galinda Paul met with an accident. He walked into a glass door and was quite severely injured. As a result, he was hospitalized. And Ambassador Galinda Paul asked his rapporteur, this young rapporteur from Fiji, Satyanandan, whether he could draft the single negotiating text. So, you know, this is a fate of history, you know. The text should have been drafted by the chairman, Galinda Paul, who unfortunately met with an accident, had to be hospitalized, and he then asked his rapporteur, Satya, whether he could do the job for him. So Satya did. So Satya accepted the text that Mochtar and I presented to him. And this is now embodied in paragraph 1 of Article 51. So if you look at Article 51, paragraph 1 of UNCLOS, this text was negotiated by Prof Mochtar and me and submitted jointly to Ambassador Satyanandan. The relevant part of Article 51.1 reads, and I read it to you, without prejudice to Article 49, an archipelagic state shall respect existing agreements with other states and shall recognize traditional fishing rights and other legitimate activities of the immediately adjacent neighboring states in certain areas falling within archipelagic waters. The question is, what does the phrase other legitimate activities refer to? In my negotiations with Prof Mochtar, he accepted my request to preserve the existing right of Singapore to conduct training activity, military training activity in waters which will in future be enclosed as part of Indonesia's archipelagic waters and territorial sea. This is an example of Prof Mochtar's fair-mindedness and pragmatism. He was a fair-minded person, and he felt, since both in Malaysia and in Singapore have legitimate interests which had to be accommodated, he was willing to accommodate them, you know. And this is an example of his greatness. If there are any doubts on what Article 51, paragraph 1 means, I want to refer you to volume 2 of the commentary of the University of Virginia on UNCLOS. And I quote from page 453. Quote, the other legitimate activities in Article 51, paragraph 1, include military uses such as training, and they have been legitimately exercised before the archipelagic regime provided by the convention was established, unquote. In his book, which I referred to, Satyanandan wrote this on pages 118 and 119. I'll read those. I'll read the paragraph to you. Quote, Article 51(1) became known as the Singapore Clause because it was included to protect Singapore's traditional fishing rights in areas that overlap with Indonesia and to undertake military training in its archipelagic waters and in its airspace above. The inclusion of legitimate activities was intended to ease everybody's tension. Among other things, legitimate activities include military training both in the sea, the air, and surrounding areas, unquote. Let me now conclude. Indonesia owes Prof Mochtar an enormous debt of gratitude. Because of his skillful diplomacy, his fair-mindedness, his pragmatic approach, he was able to win the support of Malaysia and Singapore and the other members of the conference to support the new concept of the archipelagic state and to recognize Indonesia as an archipelagic state. I hope succeeding generations of Indonesian diplomats and international lawyers will honor his legacy. Indonesia also owes a debt of gratitude to Satya Nandan of Fiji. As I explained earlier, he was the person who drafted the single negotiating text in 1976. And it was he who unilaterally inserted into the single negotiating text the provisions relating to archipelagic state. Satya Nandan had earlier co-chaired with the United Kingdom a negotiating group on straits used for international navigation. So he used the regime for transit passage through straits used for international navigation as a model for archipelagic sea lane passage. I commend to you his book, which I've already referred to, because it contains so many important insights into the behind-scene negotiation on so many difficult issues, which were fortunately resolved. And that was how we have the 1982 UN Convention on the Law of the Sea. Thank you.
Thank you very much, Professor Tomiko. So we know how was the struggle, and one of the biggest challenges is how to negotiate with Singapore and Malaysia, who are very close to us. Professor, before we continue, I would like to greet Professor Eti Agus and Professor Mika Komar. Selamat pagi, Ibu. Halo Ibu. Ibu Mika, selamat pagi.
Selamat pagi, Ibu.
How are you? Thank you for coming. Thank you for coming to this event. Ibu Eti also. Ibu Professor Eti. Yeah, how are you, Ibu? Thank you.
See the mute, Bu Eti.
Yeah.
Hello.
Halo, good morning,
Hello.
Ibu. Selamat
Selamat
pagi.
pagi.
Hello. Good morning, Professor Tomiko.
How are you?
Can you hear? Can you hear my voice?
Yes, I can see you and I can hear you.
You cannot hear me.
I can hear you. Thank you for
seems-
joining us. Thank you for joining us.
Okay. Good morning. How are you?
Very well.
Very good. A long time no see.
Yeah.
Okay.
Okay, we proceed, right?
Okay, Ibu Mika, would you like to say something? No, okay. Okay. Yeah, okay, thank you. Thank you for joining us. Thank you again, professors. It's very honor for me here, very young students of yours, to have great professors here. I would like probably take some notes from your lecture. That the difficult it's very challenging to put the concept of the archipelagic states into the unclosed. So when first we said that it was a big struggle to against the Western maritime military power, but then as a matter of fact, another big challenge is to face our own family, which is Singapore and Malaysia. However, Professor Mochtar can cope with that, and then the articles of the Article 51 is also one of the results of the negotiations result with the Singapore and Malaysia. So all of the interests of the states are there try to be completed. But yes, one of the issues is about the military activities, which is quite sensitive issue until today, I think, Professor Tomiko.
Yes, I agree.
Yeah, we have some cases. Our students wrote about research over their dissertations, like there are something unclear about what is the meaning of military activities, what is the peaceful activities, which one is not peaceful. And knowing that the advanced technology today is like taking the information from the cable, is it lawful or not, and many other.
Are you asking me a question?
No. I mean, just like I'm giving some the current situations. I mean, like it's still some issues I think about the military activities, but but probably you can maybe you would like to respond about the situations, because the developments of the advanced technology make us also quite difficult to distinguish which one is lawful and not and unlawful in regard to the military activities and training.
Maybe we should hear the two discussants first.
Okay, then. All right, I will then we'll just proceed to our discussants. We have Dr. Lowell Bautista and Dr. Guzman. Dr. Lowell Bautista is the senior lecturer and the head of postgraduate students from the School of Law, Faculty of Business and Law, University of Wollongong, Australia. Our dean also was the alumni of the University of Wollongong, Pak Idris, but I don't know whether he's here or not. And Dr. Bautista has an expertise in law of the sea, particularly in the contributions of the area territorial and maritime disputes in the Asia Pacific, especially in South China Sea. He also has an established and solid track record of research and publications in regards to the law of the sea with the government and academic institutions. He is a lawyer with over 10 years of experience in legal and policy research, litigations, and consultancy. He had a Bachelor of Art in Political Science. Also, he is also a politician, probably, but he also think like a real good diplomat, and also hold a Bachelor of Law from the University of the Philippines, and Master of Law from the Deloitte University in Canada, and Doctor of Philosophy from the in law from the University of Wollongong. I think I will not read all of the story of your of your curriculum vitae, Dr. Bautista. I will just like proceed to the response of how actually the situations in the Philippines in responding the concepts of this archipelagic states. Probably you can tell us about the role of the Philippines in the creations of the archipelagic states principle, and what the advantages and disadvantages of the archipelagic states principle for the Philippines, and also probably sharing the future visions of the Philippines as an archipelagic state to govern its marine territory. And probably you can also be responding to what the Professor Tomiko gave us on lectures about the situations on the past and the today. And Dr. Bautista, please, the screen is yours.
Terima kasih banyak, Florina. Dewi, please allow me a few moments to share my screen. And much grateful for that very generous introduction.
I think, can committees, let's, okay, here you go.
Okay, selamat pagi and good morning. Terima kasih banyak. Hope you can see the screen I'm sharing. So before I begin, please allow me to express my gratitude to the Indonesian branch of the International Law Association for the gracious invitation to speak at today's event. In particular, I extend my personal appreciation to Professor Latiful Hayat, the president of the International Law Association Indonesia branch, and Dr. Dea Jeng Wulan Christianti or Christy, the secretary and treasurer of ILA Indonesia branch, for their excellent organization of this lecture series. I'm very truly honored and humbled to speak alongside Professor Tomiko and Professor Guzman Siswandi. I've been given the task to discuss archipelagic states from a Philippine perspective. It is very difficult to cover such a historically dense and logically or conceptually or legally complex concept in such a brief span of time, but I will certainly do my best. So I wish to preface this presentation with a picture of a great man. So we have heard from Professor Tomiko, and I know that this series is actually about Professor Mochtar, but on the screen is actually a picture of another great man, and I'm sure Professor Tomiko would have been aware, and hopefully he's also friends with this great man on the screen. Yeah, and his name is Arturo M Tolentino. So Arturo Tolentino, or Arturo Modesto Tolentino, was born in 1910, and he was also unfortunately passed away in 2004 at the ripe old age of 93. And he was a Filipino politician. He was a diplomat, and he served in the Philippine Senate as a president and secretary of foreign affairs. And he is also regarded as the father of Philippine archipelagic doctrine, and he is an expert on the law of the sea. So if Indonesia has Professor Mochtar, it is my submission that the Philippines has, and his counterpart will be Senator Arturo Tolentino. It is impossible to discuss the Philippine archipelagic doctrine without mention and recognition of the great contribution that the country owes to Senator Tolentino. And by way of brief background, Arturo Tolentino was a man of humble beginnings. As a student, Tolentino was noted for his scholarship. He was also an outstanding orator, a debater. He was a lawyer by profession, a law professor, and a recognized legal luminary. Tolentino had a long and distinguished and illustrious career in government service. He was a lawmaker, and during his time in Philippine Congress, he was often involved in great intellectual battles, and he was feared for his parliamentary prowess. I could go on and on about his many achievements, but for our purposes today, suffice it to say that Senator Arturo Tolentino was the head of the Philippine delegation to the UN conferences on the law of the sea. So the Philippine archipelagic concept was first formally embodied in the Philippine Position Paper of March 7, 1955, which declared that all the waters around, between, and connecting the different islands of the archipelago belonging to the Philippine archipelago, irrespective of their width or dimensions, are necessary appurtenances of its land and territory, forming an integral part of the national or inland waters subject to the exclusive sovereignty of the Philippines. So if you look at this definition, there are some analogs or similar words to the convention itself, as Professor Tomiko read to us. They were also quite ahead of their time, because they were really the formulation of this concept, a legal fiction that the Philippines, Indonesia, Fiji, and other similar-minded states advocated and strongly lobbied for during the conferences. So the principle that you see on the screen is also later enshrined and also articulated in diplomatic correspondences. And in fact, it is also enshrined in the Philippine constitutions of 1973 and 1987, particularly in Article 1, which defines the Philippine national territory. We'll go to this in a short while. So in the words of Senator Tolentino in 1958, in the convention and the Conference on the Law of the Sea, he said that to apply the 3-mile rule to the Philippines, with every island having its own territorial sea, would have the fatal effect upon the territorial integrity of the Philippines. It would mean the dismemberment of the Philippine archipelago, with the Sibuyan Sea separating the Visayas and Mindanao, and Sulu Sea isolating Palawan from the rest of the archipelago. This and other waters would cease to be Philippine waters. They would become international waters or high seas. So you can see this very nationalistic flavor in the formulation of their statements. So they were viewing the Philippine archipelago, and of course there were developments alongside this in Indonesia happening, an embodiment of an articulation of a unity of land, water, and people, and the converse argument that if you do not allow this special regime, then the archipelago, as they have conceptualized it, will be dismembered. So it is clear that if you read the accounts of those, of course, I don't have the luxury and good fortune of being there in person during the negotiations, but I've also read as an account those who have been involved personally. It is it is clear if you read the accounts of those who were members of the Philippine delegation that the most critical aspect of the UN Conference on the Law of the Sea, and in fact the convention to them, which impelled them to actively participate in the UN conferences on the Law of the Sea, was the issue of archipelagic doctrine. The Philippines, just like any other country which participated in UNCLOS, had submitted many proposals. They advocated and lobbied for the inclusion of this proposal in the text of the convention. However, as Senator Tolentino explained during the signing of UNCLOS, the determining factor, and I'm quoting him, the determining factor in arriving at this decision was the sovereignty of the archipelagic state over archipelagic waters. So the Philippine delegation saw and seized this once in a lifetime opportunity. And you can already imagine, as very colorfully depicted to us by Professor Tomiko, how difficult it was for this tiny mid-ocean archipelagos in the Pacific to go, head to head with the major maritime powers at this time. So they were looking at the national security. They were willing to make sacrifices, but not to give up the concept of the archipelagic doctrine, which they thought was an opportune time, a time which might not come again. And they did, take advantage of this opportunity, and they seized the moment. It is safe to say that the Philippine delegation to UNCLOS was actually obsessed with the archipelagic doctrine. The only living member of the Philippine delegation to UNCLOS, hopefully Professor Tomiko has fond memories as well, is former Solicitor General Estelito Mendoza. And in 2015, in a lecture at the University of the Philippines, he stated that the archipelagic principle has, with all due respect to Indonesia, has Philippine nationality. And in his words, in our case, we were focused on the archipelagic principle. We didn't get involved too much on the others. We were just watching out as to whether any of the articles were going to prejudice our position. So they came there with a purpose. They had a clear mandate. They knew what they were asking. They also were aware of the great difficulties of securing that. But their efforts, their sacrifices, and definitely their skill definitely paid off. So in December 10, 1982, in Montego Bay, Jamaica, the Philippines signed the UN Convention on the Law of the Sea. And in May 8, 1984, the Philippines became the 11th state party to ratify UNCLOS, which entered into force in November 16, 1994. So please allow me to expound the archipelagic principles. So in March 14, 1974, Fiji, Indonesia, Mauritius, and the Philippines submitted to the Seabed Committee their basic principles of archipelagic states. And on behalf of these states, Minister Arturo Tolentino of the Philippine delegation tendered the basic principles, which read, there are just 3. So an archipelagic state whose component islands and other natural features form an intrinsic geographical, economic, and political entity, and historically have or may have been regarded as such, may draw baselines connecting the outermost points of the outermost islands and drying reefs of the archipelago, from which the extent of the territorial sea of the state is or may be determined. Secondly, the waters within the baselines, regardless of their depth or distance from the coast, the seabed and the subsoil thereof, and their super-adjacent airspace, as well as the other resources, belong and are subject to the sovereignty and of the archipelagic state. And finally, innocent passage. They should remind you of Chlorine Dewi's points about the contentious disputes about navigational regimes and the interests of the maritime states. A very, very distinctive flavor in the negotiation. Innocent passage of foreign vessels through the waters of archipelagic states shall be allowed in accordance with its national legislation, having regard to the existing rules of international law, which I think they were challenging at this time. Such passage shall be through sea lanes as may be designated for purposes of by the archipelagic state. So if you superimpose this in what is happening in other parts of the world, it is about the same time that Indonesia has also taken prior unilateral position in the Indonesian Declaration of December 13, 1957, mentioned to us by Professor Atip in his introductory lecture, otherwise known as the Juanda Declaration, which embodied Wawasan Nusantara, or the Indonesian archipelagic vision. I'm sure Professor Guzman will discuss this later on. So the Republic of Indonesia is also espousing that the archipelago of Indonesia be treated as one unit, the same formulation, where all the waters surrounding, between, and connecting the islands of the archipelago, regardless of breadth, are to be considered as internal waters. So you can see there is some inconsistency with the words of the convention later on, but you can certainly see the way it was articulated and the clarity in the terminologies that they used. So the issue and problem of archipelagos have been a long-standing issue in international law. It's not something new. In fact, prior to the declarations of the Philippines and Indonesia, there have already been attempts in the international realm to settle the unique situation of the archipelagos. For example, in as early as 1888, in its Lausanne session, and in 1928 in its Stockholm conference, the Institut de Droit International tried to draw up certain rules in the delimitation of the waters of archipelagos. But these meetings hardly adopted any definite resolution of the regime of territorial waters of archipelagos. In 1926, so I'm doing a very quick historical overview here of where the law was at that time, and the going against the grain that Indonesia and the Philippines had to go in the conferences. In 1926, the International Law Association in its 39th conference in Vienna also discussed the same question, but there was no definite stand taken. A few years later, in 1929, the draft convention on the territorial waters of the Harvard Research in International Law discussed the matter, but also no provision contained any reference to the archipelagos. A year later, in 1930, the Hague Conference for the Codification of International Law likewise failed to reach a consensus. And in fact, it did abandon the idea of drafting a definite text. So if you move forward, no agreement, we know from Professor Tomiko's explanation that no agreement was reached in respect of archipelagos in the first conference on the law of the sea. And again, it was discussed in the second United Nations Conference on the Law of the Sea, which met in Geneva in March 17 to April 27, 1960. But similar to the 1958 conference, the 1960 International Conference likewise failed to resolve or adopt the archipelagic doctrine as espoused by the archipelagic states, particularly Indonesia and the Philippines. Of course, we all know now that at UNCLOS 3, the UN Conference on the Law of the Sea, the Philippines and other advocates of the archipelagic doctrine or principle, specifically Indonesia, Fiji, Papua New Guinea, Mauritius, succeeded in codification of the archipelagic doctrine, which we find in part 4 of the convention. So as I'm principally tasked to look at the archipelagic doctrine from the Philippine perspective, please allow me to give a brief background of the Philippines. So the Philippines, as we know, is an archipelago of 7,100 islands. It's in the South China Sea. It occupies a land area of 298,170 square kilometers. It has a very long coastline of 36,000 kilometers. How is the Philippine national territory defined in domestic legislation? So historically, the Philippines traces its present title to the United States as the successor state to the territory ceded by Spain to the United States. Similar to Indonesia, the Philippines also has a very long colonial history. So the Philippines claims that it acquired its current territorial boundaries, marked on the map on the screen by what is called the Philippine Treaty Limits, on the basis of 3 treaties. First is the Treaty of Paris between Spain and the United States of 10 December 1898. Secondly, the Treaty of Washington between the United States and Spain of 7 November 1900. And finally, the Treaty of concluded between the United States and Great Britain on 2 January 1930. The Republic of the Philippines argues that the line described in accordance with the Philippine Treaty Limits, at least before, I'll go to this point a bit later on, the Philippine Treaty Limits constitutes the territorial limits of the Philippine archipelago. So as I mentioned earlier, the Philippine Constitution specifically defines the extent of the national territory of the Philippines.
I think you are muted, Lowell.
I don't know. Have I been? Okay.
Yeah.
Should I continue?
Yes, please.
Okay. So, and also in the 1987 Constitution. So it's constitutionally defined in domestic legislation. So for a long time at the domestic level, the constitutional definition of the Philippine national territory is actually the primary source of difficulty of aligning domestic legislation with the obligations of the Philippines under the Law of the Sea Convention. This constitutional definition is further reflected in domestic legislation. And in fact, the Philippines has enacted domestic legislation that provide for the various maritime jurisdictional zones, such as the Territorial Sea Contiguous Zone, EEZ, and the Continental Shelf. But these all predate the Law of the Sea Convention itself. So in the context of the country's domestic constraints, the massive task of aligning and harmonizing the domestic or municipal law of the Philippines proved to be easier said than done. So they went to the conferences, they argued for the archipelagic doctrine, which they won and able to secure and codified in the convention. But on the domestic front, within the Philippines and before a domestic audience, it took longer to align and harmonize domestic legislation. And in fact, if you read the literature in the interim, you will find that the Philippines has been very heavily criticized for its purported, position not to abide with the text and the spirit of the convention. So it actually took the country over 2 decades before. I'm actually speeding up in terms of history, and hopefully you're able to follow. So it took the country 2 decades before Republic Act number 9522, otherwise known as the Philippine Archipelagic Baselines Law, was passed in March 2009. So RA 9522 is actually technically adjusted so that the baselines and the base points meet the requirements of Articles 46 and 47 of the United Nations Convention on the Law of the Sea. If you look at the old Philippine Baselines Law, RA 3046, which was enacted in 1961, again, as I mentioned, these are laws of vintage origin which predate the convention. The statute then defined the waters includes by the baselines as internal waters. And as I said, these declarations were questioned by the international community. So going back to the new baselines law, the baselines law was indeed a paradigm shift for the Philippines. So it was an abandonment of the old Philippine maritime architecture based on the definition, the historical rights that were claimed under the Treaty of Paris. And it was a good step towards full harmonization of the relevant domestic legislation of the Philippines with international law, particularly the UN Convention on the Law of the Sea. Of course, there were further measures that need to be taken. There over the years that followed the the convention and the conference, and even after this, the ratification of the Philippines, there have been many pending laws, bills in the Philippine Congress, both in the lower house and the Senate, that sought to establish Philippine maritime zones. I'm aware at the moment that there are pending laws, bills in Congress along these lines, as well as proposals to enact a law establishing archipelagic sea lanes in archipelagic waters. So it is quite clear that there are policy imperatives for the Philippines to claim archipelagic state status. There are national security imperatives, there are policy imperatives. If you look at the geological and geostrategic considerations, there are also these reasons which underpin the Philippines to adopt UNCLOS and declare itself an archipelagic state. The Philippines, if you look at the Philippines, it's a quintessential coastal state. It is not. There is no single town. Perhaps you can say the same for Indonesia. There's no single town or city in the Philippines that is more than 100 kilometers from the shore. It has a coastline that is, as I said, very extensive. 62 out of the 71 provinces are coastal. The Philippines is clearly an archipelagic state and an archipelago. So it's constituted as an archipelago. Its 7,100 islands are compact. They're closely interrelated. They constitute an intrinsic geographical entity. If you look at the map on the screen, the Philippines has very important critical straits for international navigation. So there's the Babuyan Channel, the Balintang Channel, the Luzon Straits in the north, the San Bernardino and Mindoro Straits in the midsection of the archipelago, the Surigao and Balabac Straits in the south, and all of this interconnect points towards the South China Sea, the East China Sea, the Straits of Malacca in Singapore, and further on to the Indian Ocean and the Pacific Ocean. The Philippines is also a hotbed of geologic resources and activity. And in terms of biodiversity, marine biodiversity, the Philippines is characterized as the center of marine biodiversity. I'm down to my last two slides. So I normally, I could spend hours and hours, even days, to give you a lecture on the law of the sea, particularly on the archipelagic regime. We now know that the juridical and legal definition of the archipelago is in the convention itself. But I just want to flag this slide because I want to challenge and give you food for thought, because the archipelago is a word which is rich in ancient resonance. It also carries a lot of weight in terms of history and discourse. And of course, we can hear accounts of the convention itself from those who negotiated the convention. But we should also look at other scholarship. There is scholarship, particularly third world approaches of viewing international law, that suggests that the term archipelago is not innocent. Archipelago, as you know, it's a political, it's a legal fiction, and it's projected differently over historical epochs. It combines ideas of island, continent, empire, and nation. There are some studies which suggest that there's a violent aspect of how archipelagos are constituted. And today, as we revisit the contribution of Professor Mochtar and also recognize the efforts of those who negotiated the convention, it's important to recognize these other voices and perspectives. Archipelago or archipelagic state is also a collective identity. It also encompasses, in a sociological sense, a shared sense of diaspora and history, settlement, mobility, and change. And in my view, it is intrinsically linked to notions of national identity and nation building. I have no time to discuss this, unfortunately, but I'm flagging them merely as food for thought. After all, even speaking as a lawyer, not the legal perspective is not the only perspective. So there are ontologies, epistemologies, theoretical, metaphorical, real, and empirical powers that we need to consider when we look at the archipelago and the archipelagic state concept and the doctrine itself. This is my final slide, and thank you for your patience. I just have a few final thoughts. So again, it cannot be denied that the archipelagic state doctrine and regime is a significant victory. It is not a mean feat. As I said, you can imagine the great debates, the great oratorical skills that the Philippines, Indonesia, would have to have mustered to win the debates on the floor. And I can only imagine, because as I said, I don't have the good fortune to have been part of that. I wish I could, right? But today we celebrate, and as we should, and memorialize, and hopefully we can inculcate amongst our people this massive victory. And I want to emphasize the word victory there. So we should remember the sacrifices and the hard work of those who made this possible. Mochtar, Senator Tolentino, which I've discussed, and of course, Professor Tomiko, I mean, whose invaluable role is a running thread in all of this. So, but yet challenges remain, and there is still unfinished business which needs to be addressed. Looking at the Philippines, of course, we don't have ASL yet. We don't have the Maritime Zones Law, and I hate to mention in my final slide, territorial disputes, which I've intentionally avoided to mention. So thank you so much for your time, your patience, and again, I express my sincerest gratitude, appreciation, and I'm humbled to have been given this opportunity to share my thoughts with you today. I invite you to write your comments and questions, and I'll be more than happy to address them later on. Thank you so much.
Thank you very much, Dr. Bautista. Wow, I think it's very impressive and comprehensive, particularly when you say about the history and everything there. Oh, I'm sorry here.
I think your son wants to say something. Or daughter.
I'm sorry, that's my son. Sorry, it's always happened. Hang on for a second. I'm sorry for that. It's a motherhood, another side of the working from home. Okay, okay. Back to I would like to try to resume the Dr. Bautista's presentations first. And now we know that there's Arturo Tolentino, who also have a similar figure like Professor Mochtar Kusumaatmadja for the Indonesians, and a lot of work that has been done for the concepts of the archipelagic concept. And the interesting thing from the Philippines is the struggle is not only it's actually internally in the Philippines itself, between the senators on how to accept this concept. And I also would like to highlight that it's in responding the concept of the archipelagic state, or implementing this concept, it's not only legal perspective that is needed, but there are a lot of other things that need to be considered. And this should be we should be very proud of this, because this is our victory from the developing countries and the archipelagic countries who try to fight for our rights. Okay, thank you, Dr. Bautista. We'll let the audience keep the questions for you. Before that, I will let Guzman to give his presentations about what is actually the Indonesian situations, the perspective of Indonesia. Yes, Prof. Tommy.
I want to apologize to Guzman. I have another meeting, so I'll be leaving you at 9:30. So I may not be able to hear all of his remarks. So Guzman, forgive me for not being able to hear all of your statement. Thank you.
That's all right, Professor Tomiko.
Yeah.
Thank you. Thank you.
Okay, maybe can we proceed to Pak Guzman, or would you like to entertain for some questions or comment, Prof. Tommy, before you leave?
I'm in your hands. I'm in your hands. You are the boss. Okay. Why don't you decide?
Okay, then.
Yes, I think it would be better if maybe we can allow participants to perhaps ask some questions to Professor Tomiko.
Okay. Happy to do that.
Yeah.
Before Prof. Tomiko leave, is there any participant who would like to ask questions or comments to Prof. Tomiko?
I have such questions to Professor Tomiko.
Yes, please, Pak Atip.
Yeah. Professor Tomiko, I'm interested to your explanations about the history of Article 51 in the UNCLOS, how the negotiating between the three countries, Indonesia, Malaysia, and Singapore. My concern is on the meaning of the other legitimate activities, which includes the military training activities. I heard from Professor Hasim Jalal that the phrase other legitimate activities does not include military activities. It is only for fishing, traditional fishing activities. And when currently there is a negotiations between Indonesia and Singapore on the realignments of flight information regions. And so one of the issue in this negotiation is the inserting Article 51 into the issue of the alignments of that flight information regions. What do you think about that? Did this include the military activities, or just only for traditional fishing activities? Thank you very much, Professor.
Yeah, thank you, Pak Atip, for your question. Pak Hashim Jalal and I are also very, very old friends, and I love him. Yeah, I love him. But his argument can hold no water, because if you look at the text of paragraph 1, Article 51, the text refers to traditional fishing rights. So traditional fishing rights already referred to in paragraph 1, Article 51. So obviously, other legitimate activity must mean something else than fishing rights, right? In fact, Prof Mochtar was so generous with me. He wanted to make this clear in a bilateral treaty, you know, in the same way as he had a bilateral treaty with Malaysia. He said, look, in future generations, they may not know what the term means, and your memories fade. He was prepared to negotiate a bilateral treaty with Singapore to clarify what this phrase means. I think I made a mistake in saying, "Pak, no need," you know, that we both know what it means, and that we make sure that our younger colleagues understand the history of the negotiations of Article 51, paragraph 1. I think maybe I made a mistake.
Thank you, Professor Tommy.
Professor Tommy, there's also questions from Dita Liliansa. Ms. Dita, would you like to address the question directly?
Sure. Hi,
Yeah.
Franco. I'm Dita from CIL. So
Yeah.
thank you very much for the very insightful lecture. I have a question.
Congratulations for winning a prize recently.
Thank you, Franco.
We're very proud of you.
Thank you. You're very kind. I just have a follow-up question from Professor Atip. So it's on Article 51, because I think it's an interesting that you made a comment and on the negotiation process behind this article. But I was wondering, because during that period, Indonesia was still under the New Order regime. As we all know, during that time, military took over many high-ranking positions at the Ministry of Foreign Affairs of Indonesia. Because Prof Atip raised a very important question whether legitimate activities include military activities. So I was wondering whether there are any relations between the two, whether to your knowledge, to what extent was Indonesia's military involved in the negotiation of Article 51? And do you think it influenced, the intentional exclusion of the term military activities in Article 51? I think that's all my question. Thank you.
TNI, as it used to be known, had no role in the negotiation. The negotiation was directly and personally between Prof Mochtar and me. I made it clear to him that Singapore would oppose the archipelagic concept unless our interests are accommodated. And what are our interests? There are two interests: traditional fishing rights and the right of our armed forces to continue to train in areas of the high sea, which will henceforth be enclosed in Indonesia's archipelagic waters and territorial sea. He understood that for a small country like Singapore, this is survival, I mean, it's existential. This right is existential. So I told Prof Mochtar very frankly, if you can't accommodate these two interests, then we have no choice but to oppose the proposal. Yeah. And as I say, he's a very fair-minded guy, you know. He not only accommodated, but he said, I'm willing to conclude a bilateral treaty with you to make sure future generations understand that other legitimate activity mean military training activity.
Okay. Professor, I think we have one more question.
Yeah, sure.
Gary, please.
Thank you very much, Bu Orin, for the opportunity. Good morning, Professor Ko.
Good morning.
Yeah, I'm sorry, my question is also about Article 51, Professor. Yeah. Since this is a very burning issue right now. Professor, as you say that other legitimate activities includes military training activities, but if we look at a further text of Article 51, paragraph 1, we can see that the conduct of such other legitimate activity must be negotiated and must be regulated under bilateral agreement. Now, Indonesia and Singapore has had a defense cooperation agreement that ends in 2003 and renewed in 2007. Indonesia and Singapore has signed the agreement, but the parliament, Indonesian parliament, refused to ratify it. Now, it seems that Indonesia and Singapore are into a spiraling condition. So this means that Singapore now cannot conduct military activities in Indonesian archipelagic waters. So my question is how we should interpret Article 51, paragraph 1 to avoid such a prolonged and a never-ending negotiation between states, neighboring state and archipelagic state. Thank you, Professor, for your time.
Oh, thank you. Thank you for a good question. Very good question. I mean, there are many ways of interpreting the text, right? So I'm not saying that you must agree with my interpretation, but I tell you my understanding of para 1, Article 51, which is our right, Singapore's right, to conduct military training activity is not contingent on the subsequent agreement. You know, it is a right, and it is not contingent on whether or not we can conclude a bilateral agreement on how to exercise those rights. That's how I understood it. Yeah. I did ask Prof Mochtar in our consultation, why not use specifically the word military training activity? You know, he said it's too provocative. You know, too provocative. He said, can't we think of some other language and then we have a common understanding on what it means? You know, so we came up with the idea of other legitimate activities. So I said, you know, the two of us understand what this means, and maybe our two delegations do, but subsequently people may not understand, you know, that. But so it was important that other people should understand. That's why I referred to the University of Virginia's commentary on UNCLOS, you know, which is a very authoritative commentary on UNCLOS. And this is also why I referred to the book by Satya Nandan, because Satya was the guy who drafted the provisions of archipelagic states, you know. And Prof Mochtar and I jointly handed him the paper containing the text of paragraph 1 of Article 51. In fact, he still had that paper. And when he gave a talk in Singapore, I think Pak Hashim Jalal was there. He produced a copy of the paper and said, this is the paper that Prof Mochtar and Tommy gave him containing the text of paragraph 1, Article 51. I'm afraid with the passage of time, you know, many people would have forgotten the history of the negotiations and what the meaning of the texts are. You know, so it's important for us to have a common understanding of the negotiating process, the negotiating history of both Article 47 for Malaysia, Article 51 for Singapore.
Yeah. Okay. Yes. I think yes, that's the issue today.
Okay. So So Ibu Chlorine, please forgive me because I've got another meeting to go to. And I'd like to thank you, Pak Atip, for inviting me, and congratulations to Dr. Lowell for a very eloquent, Filipinos are so eloquent, no? For a very eloquent presentation. I was a friend of Senator Tolentino, so I know that he's as important to the Philippines as Prof Mochtar is to the Indonesian. The ASEAN delegation.
Thank you very much. Terima kasih, Professor.
Yeah. Thank you. Thank you very much.
Professor Tommy, before you leave, sorry, we would like to give you certificates of appreciation for us.
Yes.
Pak Atip, please.
Yeah.
Thank you. Thank you. Thank you very much.
Thank you very much. And committee, would you like to take some photo with us? I'm sorry, Professor Tommy. Okay. So this is our Pak Atip. Would you like to say something with us? Okay.
Thank you.
Thank you very much again.
Thank you very much. Thank you.
It's very it's very valuable.
And I'll send a text of my remark to Ibu Christie.
Yes, sure.
Yeah.
Okay. Okay.
Thank you.
Thank you. Thank you
Selamat
very
tinggal.
much.
Selamat tinggal.
Selamat pagi. Have a nice day.
Thank you.
Okay, ladies and gentlemen, because Professor Tomiko has another meeting to attend, and unfortunately she cannot be with us until the end of this meeting. But don't worry, be happy. We still have Pak Gusman and Dr. Bosisa will be available through the time to have a discussions. And I will continue to Pak Gusman. Pak Gusman will deliver the sessions about the Indonesian perspective, and I will let you introduce him, a brief introduction of him. Pak Gusman is a Vice Dean for Academic Affairs in Faculty of Law, and he graduated from the Faculty of Law, Universitas Padjadjaran in 1998, and obtained Master of Law from the University College London in 2005 as a Chevening Scholar, and finally got his doctoral degree from the Australian National University in 2014. Pak Gusman specialized himself in law of the sea, in particular regarding the natural resources, as well as so many research that he's been conducted in regard to these issues. And he also an expert and also member of the compliance committee of the Nagoya Protocol on Access and Benefit Sharing, and currently the member of the compliance committee of the Cartagena Protocol on Biosafety, representing Indonesia for the Asia Pacific countries. He's the man of probably the next Mochtar Kusumaatmadja from our faculty. Pak Gusman, the floor is yours. The screen is yours.
Thank you very much, Bu Chlorine, for very kind introduction. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, greetings, selamat pagi, mabuhay, everyone. It's an honor to be here, a great privilege to be in the same forum with Professor Tomiko and also Professor Lowell Bautista. I would like to thank the ILA Indonesian branch for inviting me, and I wish also to acknowledge my dear colleagues at the Department of International Law, Professor Atip, and also all my dear colleagues. We have also Professor Mike and Professor Ete Agus, and it's an honor also to have the presence of colleagues from other universities, and it's great also to meet also Dita here in this forum. Good to see you again, and also all the lecturers, students, ladies and gentlemen. So I would like to share my thoughts perhaps on the topic that has been assigned, which is to how can Indonesia strengthen our maritime diplomacy as the largest archipelagic state. It's a big issue, it's a big topic, so I hope that I could capture the essence in about 10 minutes. I will do my best. So I will start with some introduction, perhaps to introduce a little bit of the context of my talk, and I would like to focus on the challenges and opportunities in three, perhaps challenging issues that we currently have right now. Is regarding the maritime boundary delimitation. Of course, as the largest archipelagic state, we have so much homework to do with our delimitation, and the notion of maritime security, as well as the growing issues of the marine environment. So as an introduction, I reckon that our discussion today is also based on, in addition to the books that the Professor Tomiko has mentioned earlier, this book is also quite essential. It's from Butcher and Elson, Sovereignty and the Sea, How Indonesia Became an Archipelagic State. So I'm not going to talk into the legal details, actually, because all have been presented by the previous speakers, but I'm more interested in the, how to call it, perhaps the human side of the birth of the archipelagic state. So on page 66, for instance, there is an interesting conversation between Professor Mochtar and Khairul Saleh. At that time, he was the Minister for Veteran Affairs. So Khairul Saleh was the one who actually challenged Prof Mochtar to come up with this idea of archipelagic state, because he was very concerned with the presence of foreign, especially military foreign activities within the Indonesian waters. So it was interesting that Professor Mochtar firstly would say it cannot be done. So I think it's again the fate of history that that finally Professor Mochtar had the courage to come up with the concept of archipelagic state. And he also mentioned that it is contrary to international law. You know, if you want to draw this line connecting the outermost points of the archipelago, and you want to, if you want to restrict other states from navigating through your waters, that would be contrary to international law. And interestingly, next, Khairul Saleh said, well, if we had listened to people like you, too legal-minded, then we would not had our proclamation in the first place. So you must change your way of thinking. So I think what I see under the part 4 of the archipelagic state is like legal creativity, if I may. The main articles have been discussed, especially the Article 51, Paragraph 1. We have discussed about this extensively. But what I can observe and what I can reflect from part 4 is there are not many articles there, but it shows, it reflects this kind of again legal creativity, where you have the quid pro quo. You have to accommodate other states' interests, and you have to come up with such language that can be accepted by any state. It is not a perfect part. It is not a perfect chapter, but I think the struggle for Indonesia and also other archipelagic countries, including especially Philippines, were so successful because of this kind of creativity. You can still have you can still put your interests as an archipelagic state at the table, but at the same time, you can also accommodate other states' interests. And there is a huge, I think, challenge that was faced by our negotiators at that time, I can imagine. And I think the discussion about the nature of the negotiation during the Law of the Sea Conference is not only discussed under the preferences or books on the law of the sea, but also books on the international dispute settlement and negotiation techniques, because it was so monumental that the negotiation techniques during the Law of the Sea Convention, including part 4, is actually quite a phenomenon. So what I would like to perhaps put forward in the this morning's discussion is that there's been this kind of shift of underlying principle for archipelagic state regime if we compare between what happened when the Law of the Sea Convention was concluded and entered into force in 1994. So now it is almost 27 years after the convention entered into force. But if we can see the Part 4 of the Law of the Sea Convention, basically the articles there reflect the, I would call it perhaps the such a conventional notion of sovereignty. You want to claim your interests as a sovereign state. You want to claim your right to manage or to utilize your resources within your archipelagic waters. You want to claim your maritime territory, and you want to accommodate also navigational rights. But now, at present, I think we also have to bring this up to face the challenges that not only we have to perhaps maintain our sovereignty and peaceful claims in our waters, but we also have to face these consequences especially as Indonesia as the largest archipelagic state. We have such a growing issue of maritime security, more pressing issue of marine environment, and also the challenges of sustainable development. So in that sense, I would like to continue to my next section on the challenges and opportunities. So I think one of the obvious challenges that we have to face, of course, to finalize our maritime boundary delimitation with our neighboring countries. And the homework is so huge here. We have 10 countries we need to negotiate with. And most of them, well, actually have already established treaties or settlement with respect to maritime boundaries, except with the Palau and Timor-Leste, which is currently still ongoing. But most of the neighboring countries we have already had settled the maritime boundary agreements with respect to either its territorial sea, continental shelf, or exclusive economic zone. Not all of the maritime zones have been concluded. For instance, with the Philippines, we have been successful with the EEZ boundary, but now we still have ongoing negotiation with respect to continental shelf. Now, the issue of maritime security, I think, is one of the greatest challenges that we have to face in Indonesia. And I think it's rather different from what we had during the 1982 convention negotiations, which at that time, which I alluded to your attention earlier. At that time, Indonesia was very concerned about the physical attack or physical intervention with respect to defense and security by foreign military activities. But now the issue of maritime security has grown so much that it's not only about the with respect to the national security physically, but also with respect to marine environment, economic development, as well as human security. So I think one of the perhaps question that we can ask to ourselves, how can we respond to this kind of development? While perhaps the articles under part 4 of the Law of the Sea Convention have provided answers when you have to accommodate the security interests in terms of your sovereignty. But what about the other issues which is now a part of the growing scope of maritime security, which is not only the traditional security, but also non-traditional security. So here we have, Indonesia has established the Archipelagic Sea Lanes Passage from north to south and vice versa. And if I can show you here my perhaps from my readings from the references with respect to security along the Indonesia's archipelagic sea lanes. You can see that we have so many different concerns or different issues in each lane. For instance, in the most western part, we have issues ranging from the South China Sea situation in the north, and then we also have these repeating occurrences of natural disaster in the southern part. And in the second archipelagic sea lane, in the middle one, we have this issue of resources allocation, separatist movements, maritime safety, and people smuggling. And while on the eastern part, we have to deal with issues such as marine environment, IU fishing, and also separatist movements. So I think this kind of reflecting the growing issues of maritime security, and Indonesia also is still struggling in how to respond to this kind of challenge. One of the challenges is the institutions or agencies to deal with this kind of issues. We still have these various ministries and institutions involved in responding to maritime security threats. And in 2014, we have this Indonesia's Oceans Act, which says that, well, we will have this Badan Keamanan Laut or Indonesia's Coast Guard to coordinate all the activities with respect to maritime safety and security. But now in practice, it's not as easy as it reads on the article. So much to navigate, well, not only in the Indonesian waters, but also in the Indonesia's bureaucracy and institutional spider web. So we have the Navy, we have the Indonesia's Coast Guard, we also have the Ministry of Transport, and we also have the Ministry of Fisheries and Marine Affairs, who have been assigned also by the legislation, by the law, to deal with issues that is supposed to be coordinated by the Indonesia's Coast Guard. So this has posed challenges, and currently Indonesia is still struggling with this kind of designing the national fleet concept. So according to the book by Bowers and Co., some countries are trying to establish this central organizing principle, which, well, it's okay to have various agencies to deal with maritime safety and security, but the most important thing that you have to have this kind of central organizing principle. And now it's still in the process. The Indonesia's Coast Guard or Bakamla is trying to come up with the initiative of designing the organization of maritime security agencies involved in Indonesia. The second challenge that is non-conventional, other than delimiting boundaries, I think it's also the impact of sea level rise and climate change, for instance, on the baselines and also on the marine environment of archipelagic state in a whole. So the sea level rise here would cause some impacts also to on the delimitation of baseline, and also the maritime boundary delimitation, and it is still also an ongoing. There's some ongoing discussions in Indonesia in how to respond to this challenge. Jakarta has been here mentioned in some news as the fastest sinking city in the world. Well, although Jakarta is not, the coastline of Jakarta is not bordering with any neighboring countries, but still it at least shows a kind of evidence that Indonesia have to take more, to pay more attention on how to deal with this sea level rise and climate change issue. For instance, in 2019, the IPCC issued this special report on the ocean and cryosphere in a changing climate. And as you can see here, the report suggested that the coastal states, especially those who are vulnerable to sea level rise and climate change, can respond to these measures, whether the advanced measure, protection measures, or retreat measures. Now, Indonesia, as far as I'm concerned, we have talked about this within our academic interactions, but so far I don't think we have any specific policy to deal with kind of issue, especially the sea level rise and climate change that would have impacts on our baselines. And the final part of the challenge that I would like to discuss is that if we look at at the part 4 of the Law of the Sea Convention, again, we have so much articles that deal with the sovereignty claims, sovereign rights, and navigational rights. Now, the question is now, when we have this kind of threats, marine environment, and the growing issue beyond our jurisdiction, then how can we, as the largest archipelagic state, also contribute to the conservation and sustainable use of biodiversity? So it's not only that we now have rights to manage our resources, but I think we also have the responsibility to ensure that we have some measures in place to conserve and sustainably use our marine environment, and especially the marine resources and marine biodiversity, so it can also contribute to the sustainable use of marine biodiversity beyond areas of national jurisdiction. Now, the instrument is still negotiated since the working groups were established in 2005. Now the negotiations is still ongoing and has been postponed due to the pandemic. Now the instrument is discussed through intersessional work and informal or online discussions. These are the issues that are dealt with within the proposed instruments. We have so many new or contemporary issues to deal with, such as marine genetic resources and benefit sharing, and how can we ensure also the area-based management tools as well as environmental impact assessment. Now, maybe there's a question. Well, archipelagic state is so much a concept of sovereignty and of a nation. How can it be that this concept has something to do with something that is beyond national jurisdiction? Now, I have been fortunate to be involved in some discussions with my Indonesian colleagues, and I think I completely agree with Dr. Lowell that legal perspective is not only the only perspective that we have to take into account as a lawyers, but in the discussion of BBNJ, or biological diversity beyond national jurisdiction, I have a privilege to get some insights and knowledge from my scientist colleagues who provided this kind of refreshing perspectives that, you know, what you do within your national waters can have impacts on whatever lies beyond national jurisdiction. So the idea of ecological connectivity, I think here teaches us that whatever we do within our waters, including archipelagic waters, will somehow also have impacts on the marine biodiversity beyond national jurisdiction. So currently Indonesia, in preparing its position, but we always try to advance our interests, again, as an archipelagic state, where in our waters we have this interaction between marine biodiversity that also we can find in beyond national jurisdiction. The transboundary issues, how we archipelagic states should also take steps or measures in ensuring marine biodiversity conservation as not be used within our waters, that somehow we will connect also to whatever lies beyond national jurisdiction. So I think that that is the third challenge that I would like to put forward. And as a conclusion, again, please allow me to quote from the Becher and Elson's book. The final chapter of the book here reflects what is the concern of Professor Mochtar when he returned from Montego Bay. Professor Mochtar told the reporters at that time when he was interviewed that while Indonesians had every reasons to be pleased with the international recognition of the Archipelagic Principle, the next problem was to take full advantage of what Indonesia had gained. And in some ways, this challenge has been far more difficult than the Archipelagic campaign itself. So I think on that account, I would like to propose that to strengthen Indonesia's maritime diplomacy, I think at least we have to consider external factors that we don't only have to deal with the conventional issues arising from being the largest archipelagic state, such as delimiting maritime boundaries, but also we have to deal with these non-traditional or non-conventional issues, such as how can we, as the largest archipelagic state, deal with the current non-traditional maritime security challenges, and how can we also contribute to the sustainable development of our seas. And internally, I think we need also to strengthen our policy and regulations. We have now the coordinating ministry for the maritime affairs and investment, although in the last 2 years, I think the focus have been more shifted to the handling of the pandemic, and it is still questionable whether we can come up again with our strengthening our vision as the global maritime fulcrum, which was declared by the our president back in 2014. And I think finally, all of us here are involved in the discourses on the law of the sea as lawyers and also as educators and researchers. And I think it is our responsibility as well as an educator myself, not only as a lawyer, to ensure that we can maintain this future generations that have interests in advancing our interests as the largest archipelagic state, to continue, of course, the legacy of Professor Mochtar Kusumaatmadja, as well as Ambassador Arturo M Tolentino. Thank you for your kind attention. I will be happy to take up questions.
Well, thank you very much, Pak Guzman. Very comprehensive explanations about the current situations. As you may note that we found that the archipelagic state is actually an legal creativity, because as you open with the conversations that we cannot be too normative, probably, so seeing only in the legal perspective, because we also have to see the other way, the other situations around that. And then we realized that the current issues is not only about the physical attack to the territory, which was probably the considerations of Professor Mochtar at the time, but now we have more difficult challenges, which is to maintain not only about the boundaries, but how to manage, how to maintain what it's with the waters, the ecological connectivity, the sea level rise, which is out of our control that we cannot stop. And Pak Guzman also show us what the challenges have been faced in Indonesia is about the internal matters, about the bureaucracies and institutions puzzling, probably, if I may say so, because we have so many institutions dealing with this with these issues. But when we talk to this institution, then the institution A say, oh, that will be the job of institution B, and then we go to the B, oh, that will be C, and etc. etc. I don't know, maybe Dr. Bautista can also give descriptions. Is it also happen in the Philippines or how? Because I think it's not only regarding to the management of the law of the sea, but also in any matters. When I was working for disaster management, it's also the same, both in making regulations, policy, and also implementations. Okay, now is the questions and answer sessions, discussions. We have from Melbourne Law School. Oh, thank you very much. We have audience from Melbourne Law School. And do we have somebody in the chat? Okay, I will let, sorry, I cannot see your name. From Melbourne Law School, please. You can start your questions.
Hi. My name is Alex P. De La Cruz, and I am a doctoral student at Melbourne Law School. I would like to thank our presenters, our excellent presenters today, Professors Guzman and Bautista, for their illuminating accounts of the archipelago in international law. As a doctoral student here, I am interested in the questions of the ways in which, to borrow from Dr. Bautista, the archipelago is not an innocent legal concept. That's exactly my interest, and to echo what Professor Guzman has said, when we talk about archipelagos, most inevitably we default to the position of talking about it from the standpoint of sovereignty. And to that, I would add that when we are talking about sovereignty, a lot of what contributes to looking at the archipelago as an innocent legal concept is the concern about defense and national security. And so perhaps what I wanted to ask is, to what extent did figures like Mochtar and Tolentino acknowledge the contemporary context of their claims on the archipelagic doctrine during the years that these claims were being made? And so for the Philippines in 1955, when it issued that diplomatic note stating, the archipelagic unity of all islands and waters in the Philippines, the government in Manila was dealing with peasant rebels in central Luzon, north of Manila, and Moro rebellions in the island of Mindanao to the south of the Philippines. And for Indonesia in 1957, the government in Jakarta was dealing with the Permesta rebellion in Sulawesi. And so perhaps what I was wanting to hear was how much did they recognize the extent to which the archipelagic concept was also a device to consolidate in Indonesian and Philippine sovereignty over islands that were hotbeds of resistance to the idea of an intrinsic geographical, economic, political, and historical entity. Because not everyone is in the same boat. When we try to force the idea that there's an intrinsic entity, and this is language that appears in Article 46 of the Law of the Sea Convention when we define the archipelago. And so I was wondering if, beyond the sovereignty as national security and defense, were they also looking at what was happening in the islands that constituted the putative archipelago?
Okay, thank you. Oh, I see so many hands and I see so many people who want to ask in the chat box. Probably I will just let for this session, I will let 3 persons who deliver the question directly. And the next, I will take 3 questions from the chat box. So we'll just collect the second one. I will ask Ilona to raise the question, please.
Okay. Hello, good morning. Thank you, Bu Klorin, for the opportunity. My name is Ilona. I'm a 3rd semester student at Faculty of Law. My question is for Pak Guzman. Hello, Pak Guzman. Okay, so what Prof Tommy have mentioned before, that the success diplomacy opens up so many opportunities for Indonesia to take advantage in national development. And if we look back, they cannot be achieved without the support of the national consensus, such as a National Regional Coordination Committee, or we call Pankorwilnas, which coordinated all government agencies and other stakeholders that time. But for right now, Pankorwilnas is considered no longer suitable to be able to handle the marine problems. And I'm wondering, why did this happen? And are there any government's considerations in legal perspective to create another national body that can possibly replace the Pankorwilnas to strengthening the Indonesian's marine opportunity as an archipelagic state? Thank you.
Thank you, Elena. I think I would let the next opportunity to, I'm sorry if I not if I misspell, Itat Ong Kiao. Hello, are you there? Is that Ted Aung Kiao? Would you like to ask a question directly to the speakers?
Okay,
Yeah.
I would like to ask a question. Good morning from Myanmar. My name is Tao Job. I am a fourth-year LLB law student from University of Macquarie. I would like to ask the question that how do we protect marine biodiversity beyond areas of national jurisdiction? Thanks.
Okay. Thank you very much for the three audience who asked the question. So I will let Dr. Bautista first to answer the questions.
Thanks, Chlorine. And thank you, Alex from Melbourne Law School, for that really excellent, very insightful question. I know that Alex is writing his dissertation on this topic, so much as I would like to offer my personal views, I would perhaps defer to his thoughts. But since you asked the question, I think much of the debate, including the literature and the accounts, are really very statist in orientation, and also very Westphalian I mean, it assumes a unitary state. So if you are looking for the discordant voices, the other voices, the opposing voices, those are of course drowned out because they will not be able to capture that. And from a foreign policy perspective, of course, you sit, you participate, you advocate in the negotiating table based on on clear instructions. And of course, those instructions do not necessarily by design. They will not be able to capture every interest, every perspective. So I agree with your point. I think the archipelagic concept as a unitary, a legal, a juridical concept really codifies a legal fiction, and also, of course, glosses over a factual. I mean, it assumes that it's a factual it's factually existing, which may or may not happen from a sociological perspective. Because, as you say, if you look at it from a tableau of history, of course, there will be points in history where the unitary state as a whole did not exist as we know it today, and that will be true for all nations, not just archipelagos. So I think it's the point is excellent, but it's also unfair, because sometimes it is looking for things which will not be there, because as I said, it will be too much to ask for to look at that. Plus, although, as I said, the concept is not innocent, I think if we look at it from a juridical or legal perspective, from a normative perspective, then it makes our lives more simple. And in doing that, we avoid the peripheral questions which you raise very, very excellently. So your question actually asked how did they did Tolentino or Mochtar or Professor Tomiko account for all of these discordant or opposing voices? I don't think they ever did. And as diplomats, it would be too much to ask of them to do this. And of course, secessions occur. There are also unrest. There are, even up to now, they still exist. So unfortunately, the text of the convention, the spirit of the convention, and the negotiating history. Fortunately, I have the commentary that I have the whole set of the commentary that Professor Tomiko mentioned. It will. I don't find it there. It will not be there because it will be just too much to capture all of that. I think I'll just answer Chlorine the first question. The second question is for Professor Guzman, and also the third, I think it's more appropriate for Professor Guzman as well. Thank you.
Okay, thank you, Dr. Bautista. Pak Guzman, please.
Yes, thank you. If I may also a little bit, I have a little comment also to a question from Alex. I think what we can see, the reflection of sovereignty is I think is very obvious under the Part 4 of the Law of the Sea Convention. And if I may add, Professor Mochtar, the conversation that I presented earlier in the first slide, there was this also notion of the national security from Khairul Saleh at that time about the threats of insurgencies within Indonesia's islands. So I think the political interests are also one of the major drivers for Indonesia, especially to put forward its archipelagic state concept. And it has been successfully included under Article 46B, which says that there is an intrinsic economic and political entity. So I think the issue of this kind of bringing together all the society, islands and people within the archipelago is, I think, reflected by that political entity, and it's one of the main drivers, I think, also on considerations for Indonesia to come up with archipelagic state concept in the first place. And second question from Ilona, I think Pancon Wilnas, yeah, they have so much role in Indonesia's negotiation. Now I think the situation has changed quite significantly, if I may, because of these kind of new challenges ahead of us. I mentioned slightly during my presentation that back in 2014, our president, Indonesia's president, announced this concept of Indonesia as a global maritime fulcrum at that time. And we had so much hope at that time that finally, or at last, Indonesia put more focus or attention on the national development on its oceans or seas. And so we have also this ministry, coordinating ministry for maritime affairs and investment, which I think during its first initial years had been very active in, and in fact, it has also been successful in publishing the Indonesia's national ocean policy back in 2017. Now, of course, the question is that how should we then implement the policy, because the policy has been so comprehensive. It's still is very much general and has to be implemented in a detailed sense. So one of the challenges that we have is also with the maritime agency institutions, that now we are also still trying to establish this kind of national fleet. And I think this is also one of the key factors. If you ask about how can we strengthen our position as the largest archipelagic state, we can start with that, I think, to agree on a kind of national guiding principle, central organizing principle, that can bring together all the elements of maritime security agencies in maintaining safety and security in Indonesia's archipelagic waters. And the third question is from Het Aung Kiao about marine biodiversity beyond national jurisdiction. Well, it is still being discussed, but one of the triggers of why the negotiation was necessary, because we are still having so much international instruments in place with respect to marine biodiversity. We have also some instruments that have already dealt with marine biodiversity beyond national jurisdiction, but mostly is still confined to fisheries. And we have, for instance, other emerging issues such as marine genetic resources, and then how can we ensure that we can also implement environmental impact assessment beyond national jurisdiction, because as we know, largely the EIA is conducted within a national jurisdiction, so there is a need to coordinate between states and also to establish standards or principles. How can we preserve and also conserve our marine environment beyond national jurisdiction? We don't have the agreement now. It's still being discussed, and I mentioned due to the pandemic, it's been postponed. And the last that I read from the UN was that it will be postponed until 2022. Initially, it was planned last August, but it didn't happen because the pandemic is still here. So I hope that answers the questions. Thank you.
Okay, thank you very much. I'm a bit overwhelmed and exhausted because so many people want to ask, even though I'm not the speaker, so has to answer. Okay, I will let the audience from the chat box. I will let Sharif, Arifania, and Kunto to ask the question directly to the speakers. Sharif?
Yes, thank you, Miss, for the opportunities. So, good day, sir, Prof Guzman and Dr. Bautista. I have some question here, and I'm interested in the topic of national maritime security. I saw in your slide earlier, sir, Prof Guzman, that around Indonesia waters, there are still many threats and interfere with Indonesian maritime security. And in terms of national maritime security, can maritime culture, or as we know as budaya maritim, contribute to resolving maritime disputes, and how effective is the influence of maritime security on national marine security? Thank you, Prof.
Okay, thank you, Sharif. And next is Arifania.
Thank you, Bu Clorin, for the opportunity. Good morning. So my name is Arifania. I'm a student in International Law Class D of Faculty of Unpad, Faculty of Law in Unpad, taught by Budi Ajeng Kristianti. So I would like to ask a question to the lecturers, especially to Mr. Lowell Bautista, about an issue that happens in Philippines as a maritime state. So I just read that poaching and illegal fisheries, including by foreign vessels, especially from China, happens in the most important fisheries area in Philippines, which we know that this kind of problem is happening in Indonesia as well. But aquaculture has developed to counterbalance the decline of the natural resource. But actually, it has negative ecological effects, that is the disappearance of mangroves, or in Indonesia it's called hutan bakau. So the question is that solution is solutive for the problem, or what do you think Philippines should do to resolve the poaching and illegal fisheries problem without impacting the nature of mangroves? So thank you.
Okay, thank you, Rifania. Now we have Kunto. Please, Kunto.
Okay, thank you for this opportunity. And before I get started, let me introduce myself. My name is Muhammad Kunto Tribowo, and I'm from International Law Class D. And secondly, I will greetings Mr. Guzman Swandi and Dr. Bautista. Good morning, sir. And permission to ask related, if we look at the current condition right now, where the world is experiencing globalization and the climate warming, and it will cause problems such as rising sea levels. And this has the potential to cause like the land area to shrink. So my first question is, how can the law of the sea itself solve this problem? Maybe by perspective national law in Indonesia, and or maybe the international law of the sea itself. And my second question is, because we know that for the example, sea lengths are measured by the shoreline. And if that is the case, whether sea level rise will affect the reach of the country, for example, in terms of the territorial sea, correct me if I'm wrong, is 12 miles, or the economic zone of exclusion, correct me if I'm wrong, is 200 miles. So will this phenomenon the rise of the sea level will affect or have an impact of the narrowing of the area of this country itself. Maybe enough for my question. Thank you for this opportunity. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, all the undergraduate students, but very brilliant questions. I will let Pak Gusman first to respond to the questions, please.
Okay, thank you, Bu Gloria, and thank you for the questions. I think from Sharif, is about the how perhaps the culture of the or perhaps local wisdom of the people in the island of the archipelago can also help to contribute to the maritime security. Well, in this sense, I think there are two that comes to my mind. First, I think it's with respect to the enforcement. In some discussions with the Indonesian maritime agencies, we often find that the officers are also assisted by the local people when they spot something that could lead to the infringement of our laws, for instance, like illegal fishing, drug smuggling, etc. So especially the water police. The water police and the Navy, as well as the Indonesian Coast Guard, they maintain this kind of communication, and also to develop the community or the people in some of the islands notorious for any criminal actions or criminal acts with respect to our marine environment. And they have been assisting our officials very significantly. So I think that that's one of the aspect of how local people can contribute to the maintenance of maritime security. And secondly, I think we can also talk in terms of the protection and preservation of the marine environment. We have some local tribes in Indonesia who have maintained this kind of practice in preserving and protecting the resources of the marine environment. In the eastern Indonesia part, such as in Maluku, they have this practice called sasi, which is actually the when to harvest the fisheries in certain seasons. And then there are also a similar practice in Lombok, the southern part of Indonesia's archipelago, and also in Aceh, in the northern, one of the northernmost part of the province of Indonesia. So yeah, I agree that the community involvement, maritime culture within our society can help also to contribute to the maintenance of maritime security. And a question from Kunto, what I can say is that now we're still also discussing this impact of sea level rise on our baselines. There's you can perhaps also read the reports from the also ILA committee. They have established these committees to deal with not only the impact of sea level rise on baselines, but also the human dimension of the sea level rise. There's also the question of human rights, the displacement of people who have to move away, forced to leave because of the sea level rise. That's also a question that has been addressed by the ILA committee, and currently the International Law Commission also is still working on the principles with respect to the impact of climate change and sea level rise on the law of the sea. Thank you.
Yeah, thank you very much. Dr. Bautista, please.
Thank you, Chlorine. Really excellent questions from the undergrad. I'm very impressed. So happy to hear them and also happy to address them very quickly. So the first one addressed to me is from Arivania. So the question is, what should the Philippines do to address poaching, illegal fishing, in balancing that with the risk of damaging aquaculture and so on? So I think this is also partly responded to by Professor Guzman. So it's really a question of coordination and also enforcement. If you look at the Philippine domestic legislation, there's enough laws. I think we have fisheries laws. Also, the same as Florin was asking at the start of the open forum, we have enough enforcement agencies as well. So a lot of this happens within the domestic sphere, but also in the trilateral area where massive illegal IUU fishing occurs in the Sulu-Sulawesi Seas and also in the South China Sea, unfortunately. So domestically, there should be enforcement coordination, and if it involves trilateral issues or other states, then coordination is required. I want to address as well Kunto's point, very insightful question, because the response of Professor Guzman is spot on, because it's a legal conundrum. So you look at the ILA, there's a study group that addresses that, the ILC. I'm just reminded because the Law of the Sea Convention was negotiated in the 1960s over a span of decades. It's an old treaty of vintage origin. It's old. It's like if you look at Kunto's question, it's looking at sea level rise, disappearance of islands. It's like asking your grandfather to do TikTok, because this is an old treaty. So imagine at that time they never imagined sea level rise, biodiversity beyond national jurisdiction. So there are more newer laws or treaties in the international sphere which addresses this, UNFCCC and other. I mean, it's not to say that there's deficiency in the treaty itself, because it's called the Constitution of the Oceans. But there are some aspects which they never imagined or envisioned at that time. So I think in direct response to Kunto's question, there are two views to this, because a sea level rise, there could be what they call ambulant or moving base points or baselines. So the baselines could move. So Kunto is very smart. He mentioned 12 nautical miles, 12 nautical miles. So the first view is you would move the base points or baselines as the water level rise, or they're crystallized, or they remain as is. So of course we don't know that yet, because the state of law is uncertain. But there are scholars and people who fall on other side. So it's either that the baselines or base points adjust, and the same is true for disappearing islands. So it could be that even if they don't meet the criteria for statehood, as you would know if you look at the Montevideo Convention, their criteria, their territory, and so on, if they don't meet that anymore, they cease to exist, which is the first perspective, or they still remain to exist despite losing territory. So we have yet to see how this will pan out, because it's a very dynamic area of law at the moment.
Okay, thank you very much. I still see so many hands and so many questions, but unfortunately, we have a limited of time. We're running out of time. It's the end of our discussion time. I'm so sorry, audience. Maybe we will have a discussion in other opportunities. But for the undergraduate students, we can have more discussions on our class. And also, I also invite you to the class of International Law of the Sea with Pak Guzman as the lecturer, and me will be there probably, if he still invite me to the class. Anyway, before we close the discussion, I would like the presenters, Pak Guzman and Dr. Bautista, to deliver some closing remarks probably for the discussions. Maybe I will let Dr. Bautista first.
Thanks, Chlorine. Again, I would like to reiterate my appreciation and my honor and privilege to join you today. I think I'm also envious that Indonesia has an ILA branch. I think the first and only, I think, in ASEAN. Singapore might have one. So congratulations to the ILA Indonesia branch for organizing this wonderful, excellent dialogue. And also I am one with you in honoring Professor Mochtar for his contributions. And also I invite you to do further readings, because the Law of the Sea is very exciting. I'm speaking to the undergrad, not just the lawyers. We are in need of you, because as Professor Guzman also mentioned, and Professor Tomiko, succession is very important, because we need a fresh blood, new generation of leaders, thought leaders. So I'm happy to see young faces, and really the questions are indicative of how excellent you are. So you're receiving good education in Indonesia, And I look forward to other opportunities to speak with you, and all the best. I know we're in the middle of the pandemic, so keep safe. And I wish you, I wish that you keep well, and that we keep a positive spirit, and hopefully we will weather this pandemic as well, and we will be able to see each other in person when that opportunity presents itself in the future. Terima kasih banyak, and good afternoon. Thank you.
Terima kasih banyak Dr. Lowell Bautista from the University of Wollongong, our expert from the Philippines, the young Arturo Tolentino. I will let Pak Gusman, the young Mochtar Kusumaatmadja, probably to deliver some closing remarks.
Thank you. I'm so flattered. But if you allow me, Bu Chlorine, before I have my closing statement, I would like to address a question here from my colleague Pak Eka from Unisba. He raised a question about the role of Mr. Khairul Saleh. So I just would like to perhaps elaborate a little bit that, yeah, it was him who encouraged Prof Mochtar to come up with these radical ideas. And at the end of the day, Professor Mochtar did not do something that was contrary to international, but he in fact has contributed to the development of international law. And it was at this point also Prof Mochtar was having his sanctuary in Bandung to study this case of Anglo-Norwegian fisheries back in 1951. And there was one of the phenomenal case that inspired him to finally come up with archipelagic state concept. And I just would like to second my colleague, Professor Lowell Bautista, about the succession of the new generation of the law of the sea people. So I think now we have secured our rights as an archipelagic state. We can enjoy our sovereignty, sovereign rights. We can ensure also the navigation rights of other states. I think now is the era to finally move on to the how can we also as an archipelagic state contribute to the maintenance of peaceful and security of our oceans. And that's a huge task, but I believe that with this discussion as a start, thank you for my colleagues at the ILA Indonesian branch, Professor Atip Bukristi, and all of my colleagues for this very insightful moment. I think it's time we can pull our acts together, and together we can, I think, respond to the challenges ahead on the law of the sea. Thank you very much.
Thank you very much, Pak Gusman. Yes, I think we are one heart, because at first I would like to address the question from Pak Eka, but and then you initiatively answer it. Okay, thank you very much. Again, presenters, Pak Gusman, Dr. Bautista, it's very nice to have you here to share your thought with the students and all the audience. Also, our colleagues, Ibu Priscilia from Unsrat ACU here, and Ibu Adi, Ibu Diana, Professor Eti, Professor Mika. Thank you very much for your participation in this room. But I think it's the end of the discussion. But before that, I will deliver this to Renata, because we have some kind of another protocol to be followed. Thank you very much once again for all the participation. I feel more enthusiastic to learn about the international law of the sea, and I see there are so many students also who feel enthusiastic to learn about this issue. Thank you very much again. Assalamualaikum warahmatullahi wabarakatuh. Rere, the screen is yours.
Thank you very much, Ibu Chlorine. We would like to express our gratitude and appreciation to speakers, discussants, and also participants. And of course, Ibu Chlorine, for chairing this session. It is an honor for having all the speakers here. Once again, thank you very much, Professor Atip Latiful Hayat, Professor Tomiko, Mr. Lowell Bautista, PhD, Mr. Gusman Siswandi, PhD, and also our deepest gratitude to Professor Mika Komal, Professor Eti R. Agus, lecturers, and all the students in this international lecture. And as an appreciation, we would like to give certificates to all the speakers, which will be given by Professor Atip Latiful Hayat as the President of International Law Association Indonesian Branch. Professor Atip Latiful Hayat, the screen is yours.
Thank you, Renata. I'm sorry because of the technical problems, so I lost my connections with this room. I would like to thank my appreciations to Dr. Bautista from University of Bologna and my colleague, Dr. Guzman. We are the Australian connections. Yeah, I know Wollongong University has a strong research in law of the sea and maritime law, and also Pak Guzman from the Australian National University, and I'm from Monash University. So our discussion is dominated by Australians connections, Bu Orin. And thank you very much for all participants for this very productive discussions. And one of the most important conclusions Professor Mochtar has taught us that we don't breach law, especially international law, in proposing our ideas, our interests, national interests, but we have to make new law. We have to
Professor Atip. Oh, we would like to apologize, ladies and gentlemen. I'm afraid that there is a problem with Professor Atip's connection. To Ibu Kristianti, would you like to take over the screen, please?
Okay. Okay, since we have a problem with the connections of Professor Atip, I have to take over the closing remarks from him as a representative from the ILA Indonesian branch. So again, I would like to say thank you for all the presenters, Pak Guzman and also Dr. Bautista, for your time, for sharing with us a very thoughtful and impressive discussions about the law of the sea. Thank you so much for your time. I also very happy, especially for Dr. Bautista, who's very welcome when I invited you from the very beginning to join this session. So thank you very much. I hope we can also have further cooperations between ILA Indonesian branch and also the University of Wollongong. And also for the Vice Dean, Pak Guzman, thank you so much again for your time. And I know that you also have another meeting in 10:50, if I'm not mistaken. So I hope we can finish the session on time. And again, for the participants, thank you so much for your participation, and for your time. Okay, Renata, I give you the screen.
Thank you, Ibu Kristianti. Ladies and gentlemen, thank you for the productive session, and we look forward to more exciting discussions in the future. I'm Renata. As your master of ceremony, would like to say thank you very much for being present today. I wish you a great day ahead. Wassalamualaikum warahmatullahi wabarakatuh. Om Shanti 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 Om. Namo Buddhaya, salam kebajikan. A very good morning.
Thank you.
Thank you.
Thank you, everyone.
Bye, everyone.
Bye.
Renata and everyone. Bye. Thank you all. Thank you. Bye.